Okay, ready to dive into something pretty philosophically meaty today.
Always up for a good philosophical challenge. Where are we headed?
We're going to tackle legal reasoning,
Oh, interesting.
specifically how law uses precedent and analogy.
Hmm.
And I think, for someone like you, steeped in philosophy,
Right?
the way the legal system kind of grapples with the past
Yeah.
and with similarity,
Uh-huh.
it's got to seem pretty, well, unique.
Yeah, I can see how that would be a fascinating intersection.
Yeah. So we're going to unpack that a bit, see where those two worlds collide.
Sounds good. What are we using as our guide for this deep dive?
Well, we have a fantastic resource from the Stanford Encyclopedia of Philosophy.
Okay, I'm familiar with that.
It's an entry on precedent and analogy in legal reasoning.
Ah, yes. That's a dense one, but really gets to the heart of the matter.
Exactly. It's a very rigorous piece. Lays bare all the philosophical puzzles that are kind of baked into these legal tools.
Right, right. It's not just practical guidance for lawyers, it's a deep dive into the underlying logic or perhaps the lack thereof.
Exactly. So what we want to do today is distill all that,
Okay.
all those core philosophical challenges and frameworks
Uh-huh.
surrounding precedent and analogy, and, well, present them in a way that, someone with your background would find, philosophically engaging.
Yeah, like finding the philosophical fault lines within the very practice of law.
Exactly, exactly. And the source, right off the bat, throws us into some really juicy philosophical territory.
Okay, I'm intrigued. What kind of territory are we talking about?
Well, it starts with this question. When are two cases considered the same?
The same.
Enough for a precedent to apply.
It seems simple on the surface, but...
Right, but what constitutes sameness in this context?
Exactly. It's almost a question of legal ontology.
Right. Like, what are the essential properties of a case that make it the same as another for legal purposes?
Yes. And then, on the flip side, when are two cases merely similar? Similar.
Enough for an analogy.
Okay, so now we're getting into the realm of comparison, and that's always tricky.
Yeah. What kind of criteria for similarity do we use in a legal setting?
Right. What makes a similarity legally relevant?
And then, maybe even more fundamentally, why should a past decision,
Hmm.
in either scenario, a precedent or an analogy,
Uh-huh.
why should it have any influence on a later one?
Oh, that is a fundamental question. Are we bound by the past simply because it happened?
Right. Is it truly about rational persuasion?
Or is there something else going on, some kind of, I don't know, inertia in the legal system?
That's where the philosophical rubber hits the road.
Yeah.
This source really digs into this. It points out that legal precedent and analogy,
Right.
they aren't just like procedural steps.
It's not just, oh, we do this, then we do that.
Right. Some legal scholars argue they represent a distinct form of reasoning.
A distinct form of reasoning. So not deduction, not induction, something else.
Exactly.
Yeah.
One that might even operate outside, our traditional rule-based logic.
Fascinating. So it's not just about applying pre-existing rules to new cases.
Maybe not. And here's the thing.
Yeah.
There's no real consensus, in the legal field on what the rational basis for this is.
Ah, so even within law, the foundation of these tools is shaky.
Yeah.
Yeah.
Like, are these robust forms of justification,
Right.
in the philosophical sense?
Yeah, or are they more about just, keeping the legal system consistent, predictable,
Uh-huh.
maybe even elegant?
Coherent. Yeah. And some even question whether analogy in law,
Oh, this is interesting.
whether it even deserves to be called reasoning.
Wow, okay. So we're questioning the very rationality of a key legal tool.
Right. In the philosophical sense.
Yeah, yeah. I mean, in philosophy, we're pretty picky about what counts as reasoning.
Exactly. And even if we grant that analogy can be a form of reasoning, it immediately begs this core epistemological question.
Lay it on me.
Why does similarity, however we define it, why does it provide a reason,
Okay,
a legitimate reason,
right.
to treat two situations the same way legally?
Ah, so it's not self-evident that just because two things are similar in some way,
Yeah.
they should be treated the same by the law.
Right. It's a jump that demands justification.
It's a philosophical leap of faith.
It is. And one last point to ponder before we really start digging in.
I'm all ears.
Think about your own philosophical work.
Yeah.
You're constantly, revising your thinking, refining your arguments.
Always trying to get closer to the truth, yeah.
But the law, through precedent and analogy,
Uh-huh.
it seems to give this special weight, this almost immutable status to past decisions.
Interesting. So law is less about constant revision and more about, I don't know, respecting the wisdom or at least the authority of the past.
Exactly. So that's another big puzzle.
Hmm.
Why this unique emphasis on the past in the legal realm?
Okay, yeah, I'm seeing the philosophical contours here. This is going to be interesting.
It is. So let's actually dive into precedent first.
Sounds good.
Can you, like for our philosopher listening,
Right.
can you explain the essence of a legal precedent? Like, what is it really?
So the source defines a precedent as a court decision
Okay.
that has this unique legal significance.
Okay. Unique how?
Well, it's not just about theoretical authority, the idea that the decision was, like, legally correct.
Okay, so it's not just that the court got it right.
Right. Precedent has what we call practical authority.
Practical authority.
It actually helps shape what the law is.
Okay.
It becomes part of the legal landscape. It's
Yeah.
not just a commentary on the law. It's part of the law itself.
So are you saying that law isn't just these, abstract rules
No.
handed down by a legislature?
It's not just top down, no.
It's built up through these concrete judicial pronouncements.
Yes, that's a good way to put it. The law evolves through these pronouncements. Courts making decisions in specific cases. And, of course, there's debate about how much a single decision can change things.
Right.
But the basic idea is that precedents,
Yeah.
they're not just like footnotes.
Uh-huh.
They're treated as parts of the legal framework itself.
Okay, that makes sense. And I guess this leads us to stare decisis, right?
Exactly.
They're just kind of a bedrock of common law systems.
It's a cornerstone, yeah.
So for a philosopher who's thinking about, the nature of obligation,
Yeah.
what's the philosophical significance of this doctrine?
Well, stare decisis literally means to stand by things decided.
Okay.
And it's this obligation that later courts have
Right.
to follow the precedents set by earlier courts.
Okay.
And what's philosophically interesting here
Yeah.
is that this obligation, it extends even to decisions that might be, well, legally incorrect.
Well, hold on. So a court could be bound by a past ruling,
Yes,
even if they think that the ruling got the law wrong.
that's the idea. It might
Yeah.
seem counterintuitive.
It does. It
Mhm.
seems like a direct challenge to this idea that law should, aim for justice
Right.
or correctness.
Right.
Like, why would a system intentionally perpetuate a potential error?
That's a good question. And the source offers an explanation that really hinges on the necessity of stare decisis. It says, look, if courts were only bound by decisions that were correct in light of, the existing law,
Right.
then precedent wouldn't have any real bite.
It would just be redundant.
Exactly. Courts already have a duty to apply the law correctly.
Right.
So for precedent to have any force, it has to be able to bind courts.
Yeah.
Even when they disagree with the earlier interpretation, it's about the authority of that judicial act,
Okay.
not just its accuracy.
So it's more about the system, the authority.
Yes. Stability and predictability.
Right.
Sometimes they take precedence over an abstract ideal of correctness.
Interesting. But what about those situations where, like, the law itself isn't clear?
Ah, good point.
The source mentions legally indeterminate cases.
Yeah.
How does precedent work in those situations?
Well, in those cases,
Yeah.
where there isn't one single, correct legal outcome,
Right.
a court's decision essentially creates law.
Oh, interesting.
It resolves an open question.
So it's like they're filling in a gap.
Exactly. And in those situations,
Yeah.
following that precedent later on in similar cases,
Mhm.
it makes sense, right?
Because it creates a stable answer.
Exactly. Where things were previously ambiguous.
Okay. But let's say a court, even in a seemingly clear-cut case,
Mm-hmm.
they're just convinced that a past decision was flat out wrong.
Right.
What then?
Then we get to the power to overrule.
Overrule.
Higher courts, they have the authority
Yeah.
to invalidate precedents that they believe were just wrongly decided.
But they don't do that lightly, I assume.
No, not at all. It's a limited power, and it's usually reserved for,
Yeah.
when the error is really significant
Right.
and it's causing real problems.
So we have this hierarchy, right?
Yes, the structure of the court system matters here.
Lower courts bound by higher courts.
Right. A trial court can't just ignore, say, a Supreme Court ruling.
Even if they think it's wrong.
Even then, vertical stare decisis is pretty strict.
Okay. Now here's something I think our philosopher would really latch onto.
What's that?
This idea that a precedent only applies if the facts of a later case are the same as the earlier one.
Right, the same.
But, like, no two situations are ever identical, right?
Of course not. Every case is unique in some way.
So what does it actually mean for facts to be, the same in all relevant respects?
That's the million-dollar question. Determining relevance, that's the philosophical heart of precedent.
It can't be purely objective, right?
No, it involves judgment, interpretation, and actually, most legal disputes, they come down to disagreements about the facts.
Oh, interesting. So the facts themselves are often what's contested.
Yeah, but precedents, they come from those cases.
Okay.
Where the disagreement is about the law.
The law itself, okay.
Not just what happened, but what the law says about what happened.
So a precedent's not just a record of, like, who won or lost.
No.
It's the articulation of a legal principle.
Right.
Or reasoning. That resolved the legal issue at hand.
Exactly. Applied to a specific set of facts.
Okay. Can you give, like, a hypothetical example?
Sure. Imagine a trustee who wrongfully transfers assets to a third party. This third party, they knew about the breach of trust, and they didn't pay anything for the assets. The beneficiary, they sue to get the property back.
Right. Makes sense.
The court might rule that.
Yeah.
Because the recipient knew about the breach, right?
Yeah.
And because they didn't pay anything, they have to return the property.
I see.
So those two facts, the breach of trust and the lack of payment,
right,
those become legally significant.
So the precedent isn't just someone got trust property back.
No.
It's about those conditions.
Exactly. Receiving trust property under those conditions.
Okay.
Yeah.
But the source also talks about how hard it is to define.
Yes.
Like the right level of generality.
The level of abstraction. That's crucial.
Right. When we characterize a ruling for future cases.
All right.
How broadly do we read the precedent?
Yeah.
They have this great example, the snail and the ginger beer bottle case.
Oh, right. Classic case.
So the court found the manufacturer liable.
Okay.
Now, how do we describe what was harmful?
Right.
Was it the snail, specifically, or any contaminant?
Or like any product defect.
Exactly. The level we choose dictates how widely it applies.
Right. If it's snails and ginger beer.
Yeah.
Very limited. But defects causing harm.
Much broader.
So how do courts decide on that level?
Well, the source says the court's own reasoning is key.
Their explanation.
Yeah, their reasons often show how broadly they meant it.
Okay.
But it's not always explicit.
So it leads to more interpretation.
Right.
Okay, so just figuring out what a precedent is authoritative for.
Already involves interpretation.
It's complex.
But then the source goes even deeper, right?
Yes, it does.
Into 3 philosophical accounts of how precedents work.
3 accounts, okay.
So, first up is the view that precedents make rules.
Okay, that seems intuitive. Like, here's the rule from this case.
Yeah, most straightforward model.
Right. So the ratio decidendi.
Ratio, that's the core holding, right?
Yes, the essential grounds for the decision.
Okay.
That functions as a legal rule.
So the court identifies key facts, makes a ruling based on those facts.
And boom, they've established a rule.
That applies to similar future cases.
Exactly. Like in our trust case, the ratio could be.
Yeah.
If you get trust property through a breach and you didn't pay, you got to return it.
Okay, that's the rule.
And that ratio, that's binding, right?
Yeah, it's different from obiter dicta.
Oh, right. The side comments.
The non-essential stuff.
Exactly. Those can be persuasive, but they're not legally binding.
Okay, so in this model, we extract a binding rule from the precedent.
That's the idea.
But the source has some objections to this, right?
Oh, yes. Big ones.
Yeah.
First, unlike a statute, where the rule's written out clearly, court judgments, they rarely state their ratio so neatly.
So you have to figure it out.
Right. Infer it from the whole judgment. And even if they try to be precise,
yeah,
that wording isn't always treated as the absolute rule later on.
So it's not set in stone?
Right. It's more fluid than that.
That's a key difference, right?
Big difference.
It's like the rule is built afterwards.
Yeah, through interpretation.
Not pre-existing.
Not like a statute, no.
Both need interpretation, sure, but
with precedent.
It's more flexible.
Much more.
Okay, so that's one problem.
One problem.
But there's another big challenge to this model, right?
Oh, yes. The practice of distinguishing.
Distinguishing.
That's where a later court, they avoid following a precedent.
Okay.
Even when it seems to apply. They point to a factual difference.
They say these cases aren't the same.
Exactly. Similar, but this new fact changes things.
So back to our trust example.
Yeah.
We had breach of trust, no payment.
Right.
That's our ratio.
Uh-huh.
Now imagine a case where, yeah, the recipient got the property that way,
Okay.
but then they relied on it.
Relied on it.
Yeah, like took out a loan against it.
Ah, so they changed their position based on having the property.
Exactly. Now the court might distinguish the earlier case.
Interesting. So they're not saying the precedent is wrong.
No.
But they're carving out an exception.
It's almost like judicial lawmaking, right?
It does raise that question. They're amending the rule without overruling it.
And the source points out how strange it is
Yeah.
that lower courts can do this.
They can distinguish higher court precedents.
But they can't overrule.
Right. Doesn't quite fit with this strict hierarchy of rules.
It's like they're allowed to narrow the scope
Yes.
of a rule made by a higher authority.
As long as they still say the original case was right on its facts.
Right. It just doesn't fit neatly with the idea of precedents as, like, fixed rules.
It does complicate the picture.
The source mentions some attempts to reconcile this, right?
People try, yeah. They say maybe later courts are just, reinterpreting the ratio.
Reinterpreting.
Seeing it in light of new facts. Or there's a presumption against distinguishing.
Like you shouldn't do it unless you really have to.
Right. But honestly,
Yeah.
it feels like forcing legal practice to fit a theory.
Doesn't reflect reality.
Not really, no. Courts distinguish all the time without getting into all that.
Okay, so that attempt doesn't work so well.
Not quite, no.
Another way they try to save the rule model
Yeah, I remember this one.
is by saying that the binding rule isn't the stated ruling. It's the material facts.
Ah, so getting down to the nitty-gritty.
The facts that were absolutely necessary for that outcome.
Like the bare minimum.
Okay, in our trust case.
Yeah.
It's not any breach of trust, any lack of payment.
Right.
It's that specific combination.
That precise situation. Okay, I see.
But the source points out problems with this too.
Of course there are always problems. What are they in this case?
First, it goes against how lawyers actually think about ratio.
They don't usually see it as just the bare facts.
No, they connect it to the reasoning, to the ruling itself.
Okay, yeah.
Second,
Yeah.
how do you objectively determine which facts were truly material?
Ah, good point. It's going to be subjective.
Totally. Like, in our trust case, was it no consideration at all?
Right.
Or would, like, inadequate consideration have been enough for a different outcome?
You can't really know for sure.
No way to tell. And third,
There's more.
even this material facts thing
Yeah.
doesn't stop distinguishing.
Ah, of course. You can always find another fact to make a difference.
Exactly. Like our detrimental reliance example.
Right. Even with the same material facts, this new fact changes the balance.
So the rule model.
Yeah.
It's simple at first,
Seems like it.
but it struggles with all the nuance.
The messiness of real legal practice.
Right. All the interpretation, the distinguishing.
Okay, so what's the next philosophical account?
All right. So the second view says that precedents, they embody principles.
Principles, okay. Broader than specific rules.
Yeah. So it's not just the ratio as a rule.
Yeah.
It's the underlying justification that matters.
The deeper reasons behind the decision. Okay, interesting.
All that reasoning and judgments, it's not just extra fluff.
Right.
That's where the authority lies.
The ratio becomes more like a shorthand way of stating the principle.
Yeah. And distinguishing them.
How does that fit in?
It's justified when the facts of a new case
Okay.
mean that those original principles don't apply.
Oh, I see. The facts change the game, so the principle doesn't hold.
Or maybe they're outweighed by other principles.
Okay, so it's a balancing act between principles.
Exactly. This view, it kind of fits with this idea that law is a coherent body of principles.
Not just a jumble of rules.
Right. But even here, the source finds some issues.
Oh, I'm sure it does. What are the problems this time?
Well, distinguishing isn't always about the original justification not fitting.
Interesting. So there are other reasons why a court might distinguish a case.
Yeah, sometimes a new fact brings in a whole new consideration.
Something totally unforeseen in the original case.
Right. And this new consideration, it might be so strong that it overrides the old justification.
Okay, so it's not that the old principle is wrong.
No.
It's just outweighed by a newer, stronger one.
Exactly. And another issue is
What else is there?
how this view accounts for the ratio.
Right. The ratio still seems to matter.
Courts have to follow or distinguish based on it.
Yeah, you can't just ignore a precedent if the ratio seems to apply.
Right. And the principle view kind of downplays that. Like, it's all about the principles, but the ratio acts as this trigger.
Right. It determines whether you have to engage with the precedent at all.
Exactly. This view also makes it hard to distinguish precedent from analogy.
Oh, right, because if the justification is all that matters,
Yeah.
any case with a similar rationale could be binding.
And that's not how analogy works.
Analogies aren't automatically binding.
No. The source mentions, though,
Yeah.
that some try to fix this by saying,
Okay.
it's not just the precedent court's justification.
What is it then?
It's the best justification.
The best justification.
That fits with all past decisions.
Ah, so we're looking at the whole body of law, trying to make it coherent.
Exactly. Like Dworkin's idea, right?
Right, Dworkin. Finding the principles that make the law the best it can be.
But even this view still has to deal with the ratio
That pesky ratio.
and why some analogies are binding, some aren't.
Yeah, I can't erase those distinctions. Okay, so that brings us to the third account.
Right. The third view is
What is it?
precedents as decisions about balancing reasons.
Balancing reasons, okay. Not just a rule, not just a principle.
It's about weighing things.
Interesting. So it's more about the process of decision-making.
Yeah, so the idea is that a precedent, it reflects how a court weighed the different factors.
Okay.
All the reasons, all the circumstances.
And later courts have to respect that balance.
Yes. That specific balance on those specific facts.
Okay, so it's not that the original court was necessarily right,
No.
but their weighing of factors is binding.
Exactly. Now, the ratio.
Yeah.
It's not a rule. It's not a principle.
Okay.
It's like a shorthand for what they considered important.
Ah, so the ratio points to the crucial factors.
Yes. And the weight they gave them.
The things that tip the scales. Interesting.
So if a later case has similar factors, that precedent gives you a reason
Okay.
to decide the same way. But
It's not an absolute command.
right. It's not, you must do this.
Okay. So how does distinguishing work here?
Well, later courts, they can't just reevaluate
Right.
the original Balancing Act.
If they did that, they'd be saying the precedent court got it wrong.
Exactly.
Yeah.
But they can argue that new facts
Okay.
change the balance.
Ah, so the new facts bring in new reasons.
Right. And this explains why judgments are so detailed.
Yeah, all those facts, they were part of the decision.
Even if they're not all explicitly in the ratio.
Right. The context matters.
And the exact wording of the ratio.
Yeah.
It's less crucial than
Understanding the substance.
It's part of the reasoning. Okay, but the big challenge here
There's always a challenge. What is it this time?
is explaining how a later court is truly bound
Right.
by a precedent they think is wrong.
Ah, yeah. If the original balance was off,
Yeah.
why should they be stuck with it?
The source says
Okay.
that stare decisis is about treating earlier cases as correct on their facts.
Okay.
You can distinguish,
Yeah.
but the new fact has to be relevant.
Relevant to the legal principles, right?
Right, and it can't imply the precedent was just flat out wrong.
So you can't just nitpick. Host speaker.